Chapter 9 is based on contract considerations. A contract is a promise that requires an offer be presented, considered, accepted, and that parties will enter into a legal relationship. This chapter covers the basics of contracts, how to manage them, along with legal considerations in federal legislation. A contract starts with three things. The first is an offer, which is the initial promise that one party gives to another to either do something or not do something. There's usually a price tag included. Next is acceptance, when the person being offered something accepts the conditions. And then finally is consideration. This is something of value offered by one person in exchange for something of value from the other person. In order for contracts to be upheld, there needs to be capacity, meaning that both parties are of legal age, over 18, and have the mental capability of understanding the conditions of the promise. And then finally, the promise must be based on a legal transaction. Some things to keep in mind when managing your contracts: get it in writing so that you have something to review. Make sure the terms in the services and the costs and the deadlines are all something that you were planning on agreeing to. Keep copies so you can refer back to deadlines and eliminate any questions about what you said you were going to offer or what they said they were going to offer. And then use good faith. So don't try to deceive people in the bargaining process. In addition, include deadlines for performance and payment for products or services. Ensure third-party performance. So if you're going to use a contractor, make sure that they're of quality and that goes into the contract. Educate people. So basically explain to people in your organization what's going to happen if there's a contract breach so that they know to meet deadlines, and then resolve problems quickly so that things don't get drawn out and there's no animosity between the parties. Some things to consider in terms of legal considerations. The first is insurance. So it's important to have liability insurance. Most venues, if you're coming in and you're an outside source using that venue, will require you to have it. The next is weather. Should an event get canceled, you may want to have some cancellation insurance related to that, surrounding lightning, snow, rain, anything that may lead you to canceling an event, because you want to limit your liability. So putting your event on a track meet when it's snowing out may not be in your best interest. And then staffing of events is key to providing a safe environment. So you obviously want to hire good staff, supervise them, train them, and educate them, because it also limits your liability. In addition, what you offer during your event will dictate the types of regulations, licenses, and permits you need. Common regulations are the use of loudspeakers in public areas, performing in a public area, and building permits. In terms of food handling, hiring a food service manager with experience and proper training will ensure you have taken the necessary steps to offer quality food service. And then finally, liquor. So are you going to sell alcohol? How much are you going to allow people to buy at one time? Are you going to cut people off at a certain point so that they aren't intoxicated, and which could lead to some sort of negligence lawsuit? In terms of facilities, most facilities may not put on their own events. They look to lease the use of their facility to others. So Drake University may have leased their facility to USA Track and Field for their outdoor championships, in which would necessitate a contract. Game contracts are formed so that there are no discrepancies in terms of the agreement between the teams participating. The date, time, location, compensation for playing, travel reimbursement, rules, and regulations are always included in the contract. Sponsorship contracts are formed to protect the best interest of the parties involved. So expectations, rights, benefits, fees, terms, governing laws, marks, logo usage, licensing, and all sorts of things are included in there. And then waivers and releases. Basically, if the event is participatory, a sport competition, you'd want to use waiver because it releases the organization from liability should a participant become injured during the event. There are two primary pieces of federal legislation to keep in mind when putting on an event. The first is the Americans with Disabilities Act. So this has a number of different titles. Title III focuses on public accommodations, in that any place that's considered a public accommodation, like a sport facility, needs to have accessible seating and accessible bathrooms and so on for people with disabilities. Those buildings built before 1990 have often been grandfathered in. So anything built after 1990, this applies to. The Occupational Safety and Health Administration was created by the Occupational Health and Safety Act of 1970. And this act basically is designed to protect people in the workplace related to job-related illnesses, injuries, and deaths. So to protect employees. In event management, contracts play a large role in securing a venue, sponsors, as well as marketing deals. In order to enter into a contract, there needs to be an offer, an acceptance, and consideration. It's important to get your contract in writing and to review it to ensure that it contains the language and terms you agreed upon.